A federal judge has just issued a decisive ruling, and this time there is no appeal, no delay, and no political tactic that can stop what is about to happen. Judge Arthur Engoron of the New York Supreme Court has revoked Donald Trump's bond arrangement in the civil fraud case, issuing an emergency order on February 26th that is sending shockwaves through American law, politics, and finance. The order is stark and uncompromising. Post $464 million in cash, not assets, not collateral, not future promises, within 10 days, or face the immediate seizure of some of the most recognizable real estate properties in the United States. Hit that subscribe button right now, because what I'm about to explain is arguably the most consequential legal moment in the history of the American presidency. This is not a routine penalty. This is not a symbolic reprimand. This is a constitutional moment unfolding in real time, with a very real countdown in motion. Sources within the New York Attorney General's office, speaking on background, told reporters late Thursday night that enforcement teams were already receiving briefings on how to identify and move on assets. Think about that. Before the ink was fully dry on Judge Engoron's order, the enforcement machinery was already being set in motion. When the state begins preparing to physically seize property before a payment deadline even expires, you know something unprecedented is underway. To understand why this ruling is so extraordinary, we need to rewind and look at how we got here. In February 2024, Judge Engoron issued his original judgment in the fraud case, $364 million, which with accruing interest has now grown to roughly $464 million. The case revolved around years of alleged financial misconduct in which the Trump Organization was found to have routinely inflated property values to obtain loans and then understated those values to reduce tax obligations. The judge described this behavior as persistent and pervasive, language that many legal commentators noted was unusually direct for a civil decision of this size. Trump's attorneys went into overdrive. They sought a reduced bond and ultimately secured a $175 million bond through Knight Specialty Insurance Company. But this is where the story takes a dramatic turn. On February 19th, just 1 week before Judge Engoron's emergency ruling, investigators from the New York Attorney General's office filed a sealed submission, raising serious concerns about that bond's validity. According to sources familiar with the filing, who spoke to the New York Times, investigators said they had found what they called serious irregularities in Knight Specialty's financial records. Their allegation, the bonding company did not have the liquid resources needed to support a bond of that magnitude. In straightforward terms, the bond that Trump posted to postpone paying the $464 million may have had no real backing. Essentially just a document with no meaningful financial substance behind it. Smash that like button if this is clear so far, because we are only at the beginning. When Judge Engoron reviewed that sealed filing in a closed emergency hearing on February 25th, a session that lasted roughly 4 hours, according to court staff who later spoke anonymously to Reuters, he reached a conclusion that stunned the legal world. The bond was invalid. The protection it was supposed to offer was illusory. And under New York's civil enforcement laws, that meant the original judgment could now be enforced immediately. The stay was gone. The countdown restarted, and the amount on the table, $463,000, became fully due in cash, certified funds, or comparable liquid assets within 10 days. That decision became public on the morning of February 26th, and the political and legal landscape in Washington has been different ever since. Don't go anywhere. The most explosive implications are still ahead. Let's talk about what $464 million means in practical terms, because the raw number doesn't capture the whole impact. Based on financial disclosures filed during the fraud trial, Trump's verified liquid assets Cash, money market holdings, and confirmed securities are estimated at somewhere between $115 million and $165 million, depending on which filings and valuations you consider. That's less than half of what the court is demanding. This means that unless Trump can secure the rest through emergency financing, rapid asset sales, or some other arrangement within those 10 business days, the New York Attorney General will have the legal authority to begin seizing and selling properties to satisfy the judgment. And which properties are likely first in line? Sources within the Attorney General's enforcement unit speaking to the Washington Post on background identified several likely initial targets: 40 Wall Street, the landmark Manhattan skyscraper he has controlled since 1995, 7 Springs, the 212-acre Westchester County estate, various Trump Organization commercial holdings in Manhattan, and possibly, though sources stress this would be a last resort, interests connected to the Mar-a-Lago property, subject to complex questions about Florida law. A former New York Assistant Attorney General said on CNN the morning of February 26th, "This is not theoretical anymore. The enforcement mechanism is real, it is ready, and it will be used if that money is not posted." Drop a comment with your thoughts. I go through every single one. Now we reach the point where the constitutional implications of this case are impossible to overlook, because what we're seeing is not just a dispute about money. It is a direct test of whether the rule of law in the United States applies to a former president who is also a leading candidate in an ongoing presidential race. That core question, whether legal standards apply evenly to powerful political figures, is now in the hands of a New York trial judge, an enforcement division, and the appellate courts that may or may not intervene. Trump's lawyers filed an emergency application with the appellate division on the afternoon of February 26th, requesting an immediate halt to enforcement while the appeal proceeds. The 47-page application argues that Judge Engoron overstepped his authority when he revoked the bond, that the sealed filing from the Attorney General's office was procedurally flawed, and that executing enforcement actions against an active presidential candidate is an unprecedented judicial intrusion into electoral politics. Legal analysts who have reviewed the filing are split. Several well-known constitutional scholars told Politico that, while there are some plausible procedural points, those arguments face a very steep climb. One Harvard law professor who has argued before the Supreme Court said the filing includes legitimate procedural arguments buried under political rhetoric that courts are unlikely to find persuasive. That assessment is crucial. Historically, the appellate division has been very cautious about granting emergency stays in civil enforcement cases where the underlying judgment has already been upheld through normal appeals. The legal path to relief is narrow, the timeline is compressed, and importantly, that 10-day countdown does not automatically stop just because an emergency application is pending. Subscribe right now if you haven't already. This kind of detailed breakdown is not being done anywhere else. Now let's talk about the political shockwave happening at the same time as the legal one. Republican leaders in Washington reportedly spent the morning of February 26th in what multiple insiders described as controlled panic. Senior party strategists began emergency conference calls as early as 7 a.m. Eastern, trying to craft messaging that would defend Trump, criticize the New York judiciary, and somehow minimize the political fallout of a former president facing potential property seizures in the middle of a campaign. It's an almost impossible task. Here's why. Every spokesperson sent out to defend Trump is confronted with the same question. If your candidate cannot post $464 million in a civil fraud judgment, how do voters trust him to oversee the federal government's finances? There is no easy or convincing answer to that, and Republican strategists are well aware of it. On the other side, Democratic operatives told The Hill that ad campaigns are already in motion. According to multiple sources, they are assembling footage of Trump's most recognizable properties, the gold-plated lobbies, marble interiors, and tower exteriors, alongside on-screen text asking, "What happens when the bill comes due?" Those spots, they say, are scheduled to start running in key swing states within 72 hours of any visible enforcement action. Stay tuned, because what comes next will fundamentally change how you understand the stakes in this moment. Here's the part that should concern people across the political spectrum. This case has never been solely about Donald Trump. It has always been about whether individuals with significant influence, access to elite legal and accounting services, and deep political connections are held to the same standards as everyday citizens when courts find them liable for fraud. Here's the straightforward comparison that middle-class Americans grasp instantly. If you misrepresent information on your mortgage application, you can lose your home. You might face criminal charges. You will certainly be expected to repay what you owe. The question this case poses to the legal system is whether the same logic applies when the person involved has their name on the building. Judge Engoron effectively answered that question on February 26th, and his answer was yes. A former federal prosecutor said on MSNBC that evening, "Enforcement of a civil judgment is not political persecution. It is not a witch hunt. It is the final step in a process that has already been upheld at every level of review. The legal system is functioning exactly as designed." Despite that, the political reaction has been intense. By midday, February 26th, Trump had posted more than 24 times across his social media accounts, calling the ruling a weaponized attack, labeling Judge Engoron a radical partisan, and alleging, without presenting evidence, that the sealed filing from the Attorney General relied on fabricated financial data supposedly inserted by, in his words, deep state actors aligned with the Biden-Obama camp. He also named 3 appellate judges directly, warning that their decisions would be remembered. Commentators quickly pointed out that those comments could become relevant in future proceedings. If enforcement moves forward and Trump continues making remarks that appear aimed at pressuring or discrediting judicial officials, that could raise separate issues under New York Judiciary Law Section 750, which deals with contempt of court in civil cases. If this is all starting to feel overwhelming, hit that like button right now. Now let's look at the different paths this situation could take. Because there isn't just one possible ending, there are several, and each one matters. Scenario 1. Trump somehow produces the full $464 million in cash or verified liquid assets before the 10-day deadline. Financial experts who have examined the public records consider this the least likely scenario, but from a legal perspective, it is the cleanest. It would pause immediate enforcement, allow the appellate process to play out, and let Trump continue arguing that the underlying judgment is flawed. The political price, however, would be very high. Coming up with nearly $500 million personally while running for president raises questions about wealth, liquidity, and transparency that campaigns typically want to avoid. Scenario 2. The appellate division grants an emergency stay. Several legal sources estimate the odds at around 30%, based on the narrow procedural grounds in the emergency application and the court's historical reluctance to interfere with civil enforcement once a judgment has been affirmed. If a stay is granted, enforcement is paused. The immediate pressure eases and the case shifts back into the slower rhythm of appellate litigation. But the core issues, whether the bond was valid and whether the judgment stands, remain unresolved and could become even more politically damaging if they resurface later. Scenario 3. No stay is granted. Trump cannot post the required funds, and enforcement begins. This is the scenario that many insiders in both legal and political circles see as the most likely outcome if no major development occurs within the next 72 hours. In this case, New York Attorney General Letitia James's office would start the process of identifying, valuing, and auctioning assets. Properties would begin changing hands. The legal and political spectacle that follows would be unlike anything previously seen in American history. A sitting New York appellate judge, who could not speak on the record because of ethics rules, reportedly told a colleague, and that remark was shared with a legal journalist, "We are now in territory that the casebooks do not really contemplate." Let me know your reaction in the comments. I genuinely want to see how you are processing this. Beyond the individual scenarios, beyond the campaign implications, beyond even the particulars of this case, there is a broader American story unfolding. It is one that many voters over 45 instinctively recognize because they've witnessed, over decades, the law often being applied leniently to those with power and much more harshly to those without. At its core, Judge Engoron's ruling represents the idea that the law is not supposed to be selective, that $464 million is $464 million whether your name is John Smith or Donald Trump. That misrepresentation is misrepresentation, whether it happens in a modest loan application or in complex valuation documents submitted to a major financial institution. The American constitutional framework was designed with precisely these kinds of situations in mind. The founders, deeply wary of powerful individuals placing themselves above the law, created a judiciary intended to withstand political influence. Article 3 federal judges serve lifetime appointments specifically so they cannot be removed by voters for issuing unpopular decisions. State judges like Arthur Engoron operate under different systems, but the principle is similar. The law must be applied without fear or favor. What happens over the next 10 days will reveal a great deal about whether that principle still truly holds. Stay with me, because the consequences here reach far beyond one person or one news cycle. Here's the current status. The 10-day deadline set by Judge Engoron's enforcement order is active and running. Trump's attorneys have filed an emergency stay request with the appellate division. Financial advisors are reportedly working nonstop to determine whether any emergency financing or structured arrangement could cover the gap between Trump's documented liquid assets and the $464 million requirement. Sources close to those talks say at least 2 large financial institutions approached in the last 48 hours have declined to participate, citing concerns about reputation and regulatory scrutiny. At the same time, the New York Attorney General's Enforcement Unit has completed its asset mapping. Appraisers have been briefed. Auction procedures have been reviewed. According to one insider, the office is ready to move at midnight on day 10 if necessary. Many military families in the U.S. understand something about responsibility and consequence that can sometimes be forgotten in political circles. You take an oath, you accept the duty, and you face the outcome. The same principle applies in public office, in business, and in everyday life. You cannot claim inflated worth when it helps you secure advantages, then insist on a lower valuation when the time comes to settle accounts. At its best and most fundamental level, the law exists to enforce that principle. A former U.S. attorney said on Fox News notably, something that even interrupted the anchor. He said, "I've prosecuted fraud for 2 decades. If the facts in this judgment are accurate, these aren't close calls. They fit textbook definitions. The only remaining issue is whether we enforce the judgment, and in this country, we enforce judgments." That brief moment, a conservative legal voice on a conservative outlet stating plainly that the law is the law, might end up being one of the most important pieces of commentary in this entire story. Before we continue, make sure you're subscribed so you don't miss where this goes next. Here's the situation in its simplest form. A judge has made a ruling, a bond has been nullified, a deadline is counting down, and a former president, who could potentially become president again, is facing what may be the most significant financial reckoning in modern American political history. The implications reach far beyond one individual or one legal battle. If enforcement proceeds and properties are seized, it will demonstrate in a highly visible way that no person, no matter how famous, how powerful, or how well represented, stands above the enforcement of a civil judgment. That kind of precedent, once set, becomes part of American legal culture and will be cited in cases for decades to come. If, on the other hand, enforcement is blocked, whether through an emergency stay, political pressure, or some other mechanism, the message will be just as strong and for many more troubling. that sufficiently powerful defendants can delay, obstruct, and ultimately escape outcomes that ordinary people cannot avoid. That is not the type of precedent most judges want to create, and few serious legal observers believe it would strengthen the long-term health of the rule of law. The stakes are extraordinarily high, the legal machinery is fully engaged, and the next 10 days will help determine whether the phrase carved into the front of the U.S. Supreme Court building, "Equal justice under law," functions as a real standard or merely as a slogan. $47 billion in publicly documented real estate, $464 million owed. 10 days on the clock. One judge's order standing between the familiar way things have often worked and the way the law says they are supposed to work. We are watching. The country is watching, and history is watching as well. Take a moment to hit that like button if this breakdown helped you understand what's happening, and tell me in the comments which scenario you think is most likely. I read every reply, and right now, how you see this moment truly matters.